Hi, welcome everybody. I'm just waiting for everybody to fill up and making sure everyone's audience view works well. Just checking my screen sharing. All right. So yes, a very warm welcome. Good afternoon, everybody. Welcome to PEMUDAH's webinar series. My name is Lee Shi, but I will make more detailed introductions very shortly. But welcome, of course, to this series. We're very much looking forward to being able to share our thoughts. But I thought we will be starting off with our introductory words, of course, by Mr. Ganesh Banga. Mr. Ganesh, if you would like to start the session off.
Thank you, Lishi. Good afternoon. On behalf of the Technical Working Group on Resolving Insolvency and PEMUDAH, I'd like to welcome all attendees to PEMUDAH webinar series number 6, Post-COVID-19 Options for Companies to Emerge Stronger. I'm happy to note that we have now more than 200 attendees that have confirmed their participation in today's webinar. I hope all of you will be able to benefit from this session and will be able to learn from the esteemed panelists today, as they have got a lot to share that's very relevant in the context of today's post-pandemic era. TWGRI, or the Technical Working Group on Resolving Insolvency, is one of the technical working groups under PEMUDAH, where PEMUDAH acts as a think tank and advisor to regulators or stakeholders through strategic partnership between the public and private sector. This strategic partnership aims to drive reform initiatives that can increase efficiency and productivity of businesses and make Malaysia a more competitive nation in the international investment environment. In this new normal, one of the new initiatives to drive this strategic partnership is through webinars, which will enable the public, especially businesses, to inform and to learn how to basically understand the current business climate and how we can adapt to the new business climate. COVID-19 has changed and created a new normal in our daily lives. This pandemic presents an unprecedented challenges for business and economic activities. The adoption of the new normal and new ways of doing business are crucial to ensure the sustainable development of our economy, to ensure the survival of businesses, and to allow businesses to become even more resilient and stronger during these difficult times. Key issues on resolving insolvency, encouraging restructuring, and facilitating corporate rescue are issues that need to be looked at seriously, as we will see a lot, as we are seeing actually a lot of businesses today face challenges both financially and on the business side in surviving in this new normal. Now, during these unprecedented times, we will see a lot of large businesses close down. We will see them face challenges, especially after the September timeframe when the moratorium ends. And this one of these webinar's objectives is actually to see how we can help companies actually survive the new normal and the even more changing business environment. This webinar will highlight strategy and insights from the perspective of insolvency practitioners and legal practitioners. Companies can consider the option to restructure debts, maintain good financial position, and emerge stronger in the COVID-19 environment. We hope that this webinar will act as a platform for an exchange of ideas and views to create awareness and come up with strategies for companies, large or small, to survive in the new normal and allow for business recovery, as well as to help make the Malaysian economy greater after this pandemic hits our shores, and also I would say survive in the new normal. Thank you.
Thank you, Ganesh, for those kind opening remarks, and really to set a nice tone and the framework in which the speakers and as I, as moderator, will try to facilitate this discussion. Just a bit of housekeeping. Please do make use of the question function that you should be able to see, then I, as moderator, will be able to pick up of the questions throughout the session. We will largely try to confine the questions towards the end once we have gone through all of the contents of the talk. But in case of any burning questions or relevant questions, I may also then pose it to the two speakers. But let us then start things off with a very brief introduction that I wanted to make in terms of our two speakers this afternoon. Firstly, Ms. Khoo Popo. Popo, of course, is the Senior Executive Director of Ernst & Young, EY. I have, of course, worked with both of these speakers for over many years. We sit on various professional bodies, and in particular on IPAM as well. And Popo as well is a TWGRI long-standing member, having worked on the ground on many of these PEMUDAH initiatives, ready to try to strengthen our resolving insolvency issues. Next, Kumar Kanagasingam, partner of V. Shammuddin Allen & Gladhill. He heads the banking and insolvency practice there of VH. As I mentioned, also we've worked together, in particular on the IPAM Council, but also on our TWGRI committee together. Kumar will be able to bring a lot of legal insight from both fights within the courtroom, but more importantly, outside of the courtroom, in order to facilitate options from both the creditor and debtor's perspective when making use of various legal mechanisms that we're going to cover this afternoon. So to start things off, I wanted to try to set certain topics and certain tones to talk about in terms of to pose to the speakers. So I thought we wanted to then cover, of course, on immediate steps that I think many of our participants, you'll be advisors in companies, you'll be advisors in company representatives themselves. What is it that we should then talk about? So I wanted to then start things off by asking Popo this question. We would have been all collectively been advising many companies, they're feeling their strains in their cash flow. So Popo, what would be your advice to companies in terms of the immediate steps that they should now start to take in this sort of COVID-like environment?
Thanks, Lishi, and good afternoon, everyone, and also to Kumar, my fellow panelists. Very happy to be here this afternoon. Okay, I think when the pandemic started and when it hit our shores, I think everybody remembered it as 18th of March, where all of us have to kind of go lock ourselves at home, right? So one thing that hit everybody was cash flow, because businesses has to stop. Economy basically went on to an almost standstill, other than essential services. So on a cash flow perspective, the companies actually need to look at what is it that they need to survive. So immediate things that people tend to do would be, how do you cut off your fixed costs, right? Then, of course, the other thing that is very painful, even for a person like me, would be employers started looking at cutting employee costs and whatnot, right? So in the medium term, those were what they did immediately, because there's no business. Say you give a retailer, they can't open shop, there's zero income for them. How are they going to afford paying all the fixed costs, right? So now that the economy is starting to open up, they need to critically look at their cash flow in terms of managing it to the extent that what is it that they need to spend on and what is it they can defer, one. Second, they need to manage in terms of, can I have a chat with my suppliers? How can I better manage them? And also my customers. So of course, the ideal scenario is always been, I want to take longer time to pay my suppliers and I want my customers to pay me faster. But that's ideal, right? If we continue like that, everyone is going to collapse in a way if I just put them into an ecosystem. So there has to be some balance on this. Then come your key creditors. Okay, so one of it will be your bankers. And that conversation started fairly quickly with the initiative taken by Bank Negara to introduce those stimulus, giving people breathing space and whatnot. That is good. I think it was very much welcome, especially by the SMEs and also the sole proprietors per se. Then we have that corporates that were not given that breathing space. But then the bankers are also very understanding. They listen, and that breathing space is also given. So my advice is continue with that conversation, in a sense that keep the bankers, basically your main creditors, like your key suppliers and whatnot, updated on what's happening with the company, and of course what's happening with the business, right? As our economy start to open, I personally hope that we will not have a wave 2. Then we can look at a recovery phase, right? Then of course what I'm talking is like basically manage all these key stakeholders in running your business, right? Number 1, your bankers. Number 2, your suppliers. Number 3, your customers. These 3 have to come hand in hand. Then after that, you look at your company, your business internally. What is it that I can save on? Cut off all the frills. People have got to give. So it's whether you want to cut costs down, or the company cannot survive in the immediate short term and they have to close down. I think that is something that everybody tries to avoid, even for the business owner's perspective, or even from a creditor's perspective. I mean, it is always given, if a company goes bust, so we use that term, company goes bankrupt, creditors will lose everything, versus giving them that lifeline, and then they can then try to recover over a period of time, whether is it short, medium, long. It depends on how long that business needs time to basically turn around. Okay, then we also look at, there are cases where they just simply cannot breathe anymore. You have all these creditors coming after them, demanding on payment and whatnot. Then there's always that option of looking at getting some form of court protection and looking at what are the available mechanisms under our Malaysian law that can help them get that breathing space. Okay, I'll let Kumar explain that in further details on how those processes are. But in a nutshell, in the sense that sometimes, as much as most companies do not want to consider, you might need to consider some of these legal routes. Okay, and then there's also the other option of, if you really cannot continue in the immediate short term, you might want to look at an orderly winding down. Yes, it's unfortunate that you need to decide to close shop, but it's better to cut losses and then come back again when the economy is better. So in a way, you have that better recovery rather than continue to bleed. Yeah. So Lishi, I hope that answers that question that you had. Yeah. Then we can talk about this a bit further down today's webinar. Yeah.
Great. Okay. Thanks, Popo. And you did mention then, of course, of the different, when you may have no choice but to seek some sort of court process or a legal process or legal route. So then, Kumar, maybe you could then just weigh in now as our legal expert here on our panel. Can you then just share briefly for the on these sort of legal processes?
Yeah. Oh, thank you very much, Lishi, and thanks, Popo. Yeah, as when companies find themselves in a financially distressed position, one of the things I think take away from Popo's point is keep the dialogue open with your creditors, with your suppliers, with your stakeholders. Yeah, but in our law, and recently we have put in corporate restructuring and rescue mechanisms, that is available for distressed financial companies to be able to then use these rescue mechanisms to try and find that breathing space that is required, for them to turn around their business. Broadly, there are 3 different kinds of rescue mechanism available under our Companies Act. One is a scheme of arrangement. The other is a corporate voluntary arrangement. And the last one is judicial management. A brief intro in each of them. A scheme is basically a court-sanctioned compromise between a company and its creditors. Yeah, the advantage of a scheme of arrangement is that the debtor is still in possession of his company. He is still in charge of the company. Yeah, it is fairly popular scheme that some debtors undertake, and it was earlier the only rescue mechanism that was available. Post 2016, under our new amendments to Companies Act, 2 other rescue mechanisms were introduced, and they were, of course, the corporate voluntary arrangement, and the other one is judicial management. With regard to corporate voluntary arrangement, this is basically a company that has not given any charge to the creditor. It's got some cash flow issues. It's a simplified manner in which you can reach an arrangement with your creditors. Yeah, and a more complex rescue mechanism provision was also introduced in the 2016 Act, and that is judicial management. And this is basically a court-supervised rescue plan where an insolvency practitioner will be appointed as a judicial manager who will then propose a plan to organize the affairs of the company. Yeah. So these are basically the 3 rescue mechanisms that are available. Now, I just touch upon the thing with regard to which companies have the eligibility of these companies to partake in any one of these 3 mechanisms. We'd like to highlight a few points. With regard to scheme of arrangement, it is available to any company, yeah, under the Companies Act. There's not much restriction. So long as you want to reach a compromise with the creditors, any company can then apply for a scheme. However, with regard to a company voluntary arrangement, there are certain classes of companies that are precluded from using this mechanism. And they are: 1, a public company; 2, a licensed institution or operator of designated payment system under laws regulated by Bank Negara; companies that are subject to the CMSA 2007, i.e. licensed companies; then companies which create a charge over its assets. So it's very important here, if a company has created a charge over any of its assets, then that company will not be able to use CVA as a mechanism for rescue mechanism. However, that doesn't mean that there are instances where the major shareholders of the company may have created a charge over their assets. Those companies are eligible to then apply for CVA. Yeah. Then with regard to judicial management, likewise, it is not available to a licensed institution or operator of a designated payment regulated under the laws enforced by Bank Negara, and also any company that is subject to the CMSA. And there is a debate, but I think most cautious practitioners will say that judicial management is not available to public listed companies. Yeah, so that's a point I think to remember. Now, with regard to who can apply, obviously in respect to a scheme of arrangement, the company itself can apply for a scheme. Any creditor or a contributory of the company can also apply for a scheme of arrangement. A liquidator, if the company is being wound up, if it thinks that for some reason it is better to reach an arrangement with most of the creditors or a class of creditors, then it's also available to a liquidator. And of course, like I mentioned earlier, some companies may adopt the position of going and getting a judicial manager appointed, and a judicial manager may also apply for a scheme of arrangement. With regard to a CVA, the directors of the company that is not under judicial management order or being wound up may apply. So long as the company is not under JM or the company has not been wound up, any director or directors of the company may apply for a CVA. A judicial manager if a company is appointed under JM, or by a liquidator if a company is wound up. Yeah. And then finally, with regard to JM, the company or its directors and any creditor of the company. So JM is fairly similar to that of a scheme of arrangement. Maybe I'll quickly run through the procedures that is required. Just the steps, I won't go into too much of a detail. With regard to scheme, it's applied to court for an order to hold meetings. So in essence, what you have is that you immediately go to court and you get an order from the court to convene a creditors meeting. And a creditors meeting may be one if it's all unsecured creditors, or if there are different classes of creditors, then you may obtain an order to hold separate meetings for each class. Yeah, and once you have obtained that order, you then subsequently you get generally an IP practitioner comes in to assist them to come up with the scheme or whatever is the proposal that the company intends to make to its creditors, and thereafter a meeting is then held. Okay. If it's different classes of creditors, then separate meetings are held. And if 75% of the creditors in each class approve the scheme, then the scheme manager can then bring that scheme back to the court, notify the court of the approval by the creditors, and the court will then endorse the scheme. And thereafter, the scheme will be binding on all creditors of the company. So that's in essence what a scheme of arrangement is. With regard to a CVA, as I earlier mentioned, it's a simplified process. And in essence, again, you need to have an IP practitioner who prepares a proposal. Yeah. Directors then shall appoint a nominee or to implement the proposal. The nominee must be of IP practitioner, and then thereafter the directors then submit to the nominee the document setting out the terms of the CVA and the statement of the company's affairs. The nominee, being the IP practitioner, then assesses the situation and submits a statement of his to the directors on the viability of the proposal. Yeah. If the nominee approves the proposal, then the relevant documents are then filed in court. Yeah. Just merely proposal given to nominee approves it, gives an opinion. Thereafter, all these papers are then filed in court. And the advantage is the documents that are needed to be filed in court obviously are the nominee statement, the nominee's consent to act, and documents setting out the proposed terms of the CVA. But the advantage of a CVA is once you file these documents, immediately you have a 28-day moratorium. In essence, it means that nobody can take action against the company within that 28 days. Thereafter, you are supposed to then convene a meeting of the creditors and members to see if they approve the scheme, and if the proposal is approved at the meeting, the proposal takes effect and binds the creditors. Yep.
Kumar, in fact,
yep.
What you had mentioned there, which was quite very useful, where you mentioned is a very important feature, being that 28-day moratorium.
Yep.
In fact, that tied into what I thought was going to be important, and something that also Popo hinted at just now. I mean, one of the most immediate queries that a lot of the distressed companies now be worried about is to, whether the bank moratorium loan is lifted in September, whether there are already threats of legal action. I mean, you through schemes, what you mentioned about CVA, JM, where is it that I can get all this, important breathing space or legal protection? Could you maybe just share a little bit how these three different processes come about, giving some critical breathing space?
Yeah, sure. With regard, like you mentioned, I think CVA is the most ideal, because what happens is you get an automatic moratorium for at least 28 days upon you filing the papers that I mentioned earlier. With regard to a scheme, there's no moratorium, but what happens is you as an applicant may apply to court for a restraining order. And as long as then you meet the criteria that's prescribed in the Act, the court may grant you a restraining order, basically restraining all creditors from taking action against the company pending the holding of the meeting of creditors and pending the approval of the court subsequently. There's of course criteria with regard to obtaining the RO. Certain things that you got to fulfill, but one of the important thing is generally, I mean, there were two schools of thought with regard to whether you can make an ex parte application or an inter parte application. But I think the latest cases seem to suggest that in fact, if you have existing creditors who have already taken action against the company, you should at least serve that application on them. Yeah, I think that's quite important. And then, of course, there are other issues with regard to obtaining an RO, and these conditions that simply this: the court needs to be satisfied that the restraining order is necessary to enable the company and the creditors to formalize the proposed scheme. There must be a statement of particulars as to the affairs made up to the date of the order or the application. The next one, the court then approves a person nominated by the majority of the creditors to act as a director. And this is important. So that therefore, one of the requirements is that the court requires this director to be independent during the time of the RO to sit on the board, okay, to ensure that the company doesn't use that for or abuses the RO. Yeah, and then the final thing is that of course the RO may be extended. The RO is only granted normally for 3 months, but it may be extended for not more than 9 months. Yeah, so that is with regard to the scheme. So scheme of arrangement, you need to apply, fulfill the conditions to obtain the RO. With regard to judicial management, it works similarly to that of the CVA, in the sense that you prepare the application. I'll just go through. I think I haven't highlighted what were the requirements. If I may go through it quickly. The first is that the application made to court by way of an OS with a supporting affidavit. The applicant nominates a judicial manager who's an IP practitioner. The application must be advertised widely in a widely circulated newspaper. This basically is to give notice to everybody dealing with the company, more so the creditors, that you are attempting to go and get a judicial management order. Okay. Upon the making of the application, the hearing date shall be fixed within 60 days. At the hearing, the court may either grant judicial JM order, adjourn the hearing, or dismiss the application. Yeah, and there's a debate as to whether, but generally it's taken that a secured creditor can, of course, oppose the JM order. Yeah, after the JM is granted, that is just the order for JM is granted, the judicial manager shall have 60 days or longer period which the court allows for him to then submit his proposal to all the known creditors of the company. Okay, the JMO lasts for a period of 6 months, and you have a moratorium during that period. Yeah, so this is where the same issue comes in. You have a breathing space. Yeah.
All right. Thanks, Kumar. And then I guess Popo, I mean, have you ever seen what are some of the practical difficulties when you are trying to advise a distressed company?
Before you get such an order or such a breathing space, some is automatic. Yeah. Yeah.
Yeah, I think
yeah.
In terms of getting the moratorium, I mean, in terms of getting some breathing space, like I said just now, number one is constant communication with your key stakeholders. So in this case, I'll normally just put them to 3 big buckets. Your lenders that has been supporting the business, your key suppliers, and of course your key customers. You know, basically these 3 key stakeholders are very important. So if you say you want to get this breathing space, sometimes having an external advisor that these stakeholders are comfortable with would help. Having an external advisor that can support you in what you're doing. Then, of course, alternatively, you know, sometimes client will ask me, Popo, can I do this myself? I say, by all means, you can do it yourself, you know. But in my experience in advising client, there was one client that told me, he says, you know, Popo, I've run this business for 20 over years, you know, but I've never, what we did was we were trying to transfer a business to another entity as part of a group reorg, right? So they had to transfer things like licenses. Then they said, in my 20 years of working in this company, you know, the company just goes on day in, day out, day in, day out. I never have to shut down one and push it to another one. So that cessation part or that difficulty part is something not everyone is used to doing. Okay, the running the business, the building the business, I would say the business owners are the experts in those fields, right? So then comes in the sense that then do I need this third party to come in? What are the benefits of having this third party? Okay, lawyers are very clear. They know that if I want to take those mechanisms, I will need a lawyer to act for me, to go to court, to present my case and all that. Then the thing is, okay, do I need this third party to come in? I say if you can do it yourself, then you just have to make sure the key elements and what is it that these stakeholders are interested in manage, then you can do it yourself. Alternatively, you can get an independent, I'll use the term advisor to assist you in terms of working out that cash flow of working out in terms of what is it that your business can support, when can you pay, how much, and how are you going to pay. Okay, then if that still doesn't work and you need some form of breathing space, this is when Kumar mentioned about having a CVA process, a corporate voluntary arrangement, or a judicial management process where you have this third party. Okay, I'll call this person an expert, you know, in their field, to come in to, number one, help you work out the numbers of how much you can pay, when you can pay, how are you going to pay. Then this individual will act as the new face to negotiate the creditors. Okay, so pros and cons. Maybe I will just cover the pros first, in the sense that this person will just be the one that does the, I would say, the bad guy stuff lah. In a sense, will tell the supplier in the sense that, hey, I need 50% haircut, you know, a discount, you know, and company needs 3 years, 5 years to pay it. Okay, so it's not so much as this person is just for the fun of it, just want to ask the supplier to give a discount. It's more of, this advisor needs to be able to substantiate in the sense, why is it this company need that haircut lah? It's a term that we use. Okay, so that the role of the advisor is also important. You're not just out to try and confuse the creditors, you know, but to tell them in a sense that we have taken an independent view of the business, and this company, given its current cost and speed, can be able to afford this. Okay, then of course, when we do a scheme, there are many variations. Some may have upside, in the event the company's cash flow improve, if business improve, which is the plan, of course, in any restructuring exercise. But then there are some that can only afford what they can pay. So come this role, you can say, okay, you can be an independent advisor that comes in as an external party, like just a typical advisor. Or if you take a CVA route, then this person will come in as a nominee. So once the CVA happens, of course, you have that should I call it a force field around the company. People cannot take action and whatnot, right? Then of course we have 366, but that involves certain processes to go in before you can get that restraining order. Again, I use the term force field. Okay, then the 366 now has become a bit challenging because of how people have interpreted the law. Then we go back to judicial management, the so-called new kid on the block, right? So judicial management makes it a bit simpler in the sense that, okay, when I say simple, what I mean is the moment you file, you get that automatic force field, right? Then the company also has that option. Once you file, this process needs to take time to be heard in court for the order to be granted. So during this period of time, you have that force field, but the directors are still in charge, right? Regardless whether this application is made by the company or by the creditors. Let's just take these two extreme angles, okay? So then the company and the creditors will look at it in a sense that, directors are still in charge. Are we okay with it? If you're okay with it, fine. But if we think we need someone inside, I mean, independent person again lah. So we say, okay, I can have my independent financial advisor there, am I right? Would that solve it in terms of being the face to negotiate with the creditors, right? That's one way of looking at it. The other way of looking at it is maybe I should consider putting in an interim judicial manager who is a court officer who will act impartial to all creditors in order to be able to manage the creditors per se. So by having that independent face, sometimes because the company is still alive, bear in mind when they go through this judicial management process, you're not talking about closing it down or what. The company is still alive. They're trying to survive with the view of turning around, right? So whilst they're still operating, right, having this new face to negotiate with creditors sometimes do help. But then the management of the company, meaning directors and whatnot, still need to cooperate with the interim judicial manager or even the independent financial advisor to actually work out in terms of how do we manage these key stakeholders whilst we so-called come up with a restructuring plan. Okay, so those are important. Whilst when you are, what are you going to do when you have that force field, in the sense that it's not sit pretty, but then more of like you need to be doing something to get out of the problem that you're facing. Yeah.
And in my experience, and primarily I have been acting for lenders in my entire practice. One of the things is when you're dealing with financially distressed companies and you want to appoint an insolvency practitioner or independent financial advisor, I think it's very, very important that person has got a rapport with the lenders. Because with regard to financially distressed companies, although I think you may have trade suppliers and your unsecured creditors who may be taking action, but if you do not get the lenders or the secured creditors on board for whether it's going to be a scheme or a proposal of a CVA or even a judicial management, it's unlikely that you are going to succeed in any one of these rescue mechanism procedures that are available. And so to get the secured lenders on board, your IP practitioner or the independent financial advisor must have a good rapport with the banks. This is my observation over the years. Yeah.
There's what I liked how Popo used the term legal force field. in that it is protection from legal actions. But I throw this question to both of you because it's a common question that I'm now facing with a lot of ongoing queries. What happens when we do undertake any of these legal processes, because we are a distress, or we are acting for a distressed company, or we are a distressed company, and there's now a risk of it triggering an event of default under bank documents or financing documents. It may trigger an event of default under, a main ongoing contract that we're doing. Because the legal force field won't extend to that, or at least based under our existing laws. How do we manage breathing space to make sure we still have trade lines and can get the banks on our side, or major contracts can still continue? Any ideas from Popo or Kumar?
Maybe quickly, I mean, as you all know, the government has come up with this order that during I think the 6 months from March after the MCO, you could not actually attempt to issue a statutory notice to wind up a company. So that's an interim. There was this thing in place. Two, of course, the banks have, of course, given a moratorium. But I think it's very important that as business start, you got to engage and have a dialogue with everybody, all the stakeholders, with regard to what your plans are and how you're going to execute it. And I think if you are upfront with all the stakeholders, then right from the beginning and say that this is the plan, this is how we are going to now come out of this crisis, they will probably try and help you, because it's no point. They may not want to wind you up, or they are unable to wind you up, but if they take action, you're going to die, or the company is going to die, and it probably will also kill the supplier because his business is also going to be affected. So it's a situation. So I think dialogue at this moment in time, I think, is very important. Yeah.
I mean, just to add on to what Kumar has shared. I mean, Lishi, you talk about trade lines and whatnot. Put it this way: the banks can only continue to give the trade line if the account is in performing. So the advice to businesses is to start thinking about this early. Don't wait until it's too late, because bear in mind, to work out a plan, it needs time, right? So if they start too late, right, the banks are starting to pull the lines. They have to do what they have to do. There's no way they can continue to let you have those trade lines. Then comes like what Kumar was saying, talking to the stakeholders, talking to your suppliers and your creditors, So if you don't have trade facility, there's a possibility that the business will probably have to run at a lower volume, because you're running on basically your so-called working capital facility from your creditors, and also from your suppliers and your customers per se. I won't say that it's entirely not possible. It is possible, but with you looking at some of the working capital initiatives internally in terms of how can you conserve your cash and how can you generate more cash along those lines. It's a matter of balancing left and right pocket, and at the same time still continue to sustain your business at a certain level that you can cover your fixed costs. And then if you can get that force field, it is very good. If not, then so the advice I always give is start early. I mean, trust me, no one would ever want their business to be in that position. Okay, but when it happens, one, like what Kumar said, make sure you get the right advisor. And the second one is, like I say, just act as early as possible. Talk to the lenders, talk to your stakeholders and whatnot. Yeah.
Okay. Thanks for that insight. I mean, we have what we've had is, of course, immediate first steps. We have understood legal options, and if we have to go down the court or Companies Act routes, and which will then hopefully buy us also legal force fields via breathing space. But I guess the next part of where we must then next to consider is that there needs to be an eventual plan. There needs to be something, and I think even Kumar himself has already mentioned that, right? There must be some sort of proposal or compromise or something that we're going to be able to put forward to our creditors that, yeah, how are all of these debts payments going to be done? So maybe if Popo could then share a bit, what is it that, or how do you put together? What are your thought processes? What are your building blocks to actually put together this plan moving ahead in very general terms? Yeah.
Okay, I'll keep it general. Number one, the company needs to be able to show that it is able to continue to operate, right? So continue to operate will be like there is future, current and future business coming in, able to cover your operating costs. Then comes the part about what about my old debts? I call old debts as in the debt before the restructuring process, to keep it simple. So the old debts, if we need to achieve some compromise, then it works out in terms of based on the cash flow, how they can pay, when they can pay. Then of course, if the business itself cannot save itself, then comes in the sense that do they need a new kind of like a savior, which everybody likes to use the term white knight. Okay, so white knight can come in many approaches. I would say they can come in as a new shareholder, inject funds as a shareholder, then you got money, or they can inject assets, or this company can be injected into another company per se. So ultimately, it's more of like when we present a proposal, a lot of people want to know where is your source of funding, right? So if you say existing business, usually not that easy because existing business, maybe you can settle from your business from now moving forward. But what about the old debts again? The old debts has to be settled. Then you say, never mind, my existing business, I will settle, I will allocate some to settle, but it will take a very long time, and most creditors will not have that patience for it. So creditors may look at it in the sense that, what's in it for me? So to creditors, I would tell them in the sense that what's in it for you is you have a chance for this scheme to go through, like Kumar said, if it's a JM, it's just a 6-month period, or max 12-month period, or even if you do a 366 restraining order, that is also a 12-month period. If that fails, you still have the option to kill it, winding up, right? So the question is like, should I give them the chance or should I just kill it, right? For them, for a creditor to consider whether to give them a chance is put it this way, the credibility of the plan, how strong it is, or is it just a bunch of numbers that they pick from sky, not substantiated? They can give you some third-party reports, but someone needs to look at it in the sense that, hey, is this for real? Is this going to happen? It looks nice on paper that I'll get paid, blah, 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 but will it work? So this is something creditors would look out for. So of course, in the course of us discussing that restructuring plan per se, everybody would want to have that, hey, pay me more pay me faster So that balancing of the stakeholders is not easy. Okay, so we will need to manage those probably. When I say we, meaning advisors and also the company itself because the company need to show that they truly believe that the business will be able to turn around. I think that is very key. Yeah.
Let me put Kumar on the spot a bit, because I'm going to pick up on the fact that he tends to, a lot of his work has also been creditor driven. Can you just share some war stories then, perhaps, where there were successful proposals that then creditors thought, look, there was buy-in, some of the plan, the restructuring proposal made sense, and then hopefully it was a success story. Just to give an idea to the audience.
Yeah, I think when a secured creditor looks at a plan, the proposal that is given by the financial distress company, generally being the secured lender, so long as their security is not in any way in jeopardy or it's not been eaten in, okay, I think they will then be able to then look at the plan to see whether it's workable and assess the credibility, assess the strength of the plan, and so on and so forth. Because generally, even banks do not want to kill their customer. Yeah. But once it is shown that the liability of the company has exceeded that of the assets that have been secured to the lenders, then it is very unlikely that the lenders would go along with any plan where further credit is to be extended to the financial distress company. Yeah, but having said that, there were occasions, and this I think if you go back to the major times when we had a financial meltdown in Malaysia. I remember in the mid 80s, then even in 97, when you have a widespread financial distress situation like we are facing right now, then the banks are a bit more hesitant, because I think it's also driven by the fact that the regulator then comes in, because regulator will probably advise the bank, don't simply go and pull the plug, because that will mean that the entire economy is going to collapse. So regulators also then play a role, and therefore the action or the banks will take would probably primarily depend also on what the regulators are saying. But the nutshell is, if the security is affected, generally secured lenders will start taking action.
All right, thanks. Thanks, Kumar. Thanks, Popo. Then let me just go back to slides. I mean, we have given some insight on the components of a plan, and Kumar ended off by showing how, from a secured lender's perspective as well, what should be some of the minimum elements that could lead to a successful plan. I thought we would, and thank you very much again to a lot of the people who have been posing questions. I, as the host, have been seeing the questions come in. So please, just from time to time, if anything else comes to mind, please use the questions function, and we will definitely try to address as many of the questions at the Q&A session. But I thought that to bring all of these elements together, immediate steps, we're talking about trying to get enough of a breathing space, putting together the components of essentially the rescue plan. Let's try to apply it to a hypothetical case study, right? Name is all made up, but perhaps it's a business that many of us can relate to. I want to talk about a case study of Highland Hotel, where the facts, very briefly, are going to be as follows. I'm going to try to invite both of the speakers to try to weigh in, and let's walk through this study. Highland Hotel itself, Sdn Bhd, so private limited. It operates 3 high-end hotels around Malaysia. Like many in the hotel industry or hospitality or the tourism-related industry, badly hit because of the MCO. They have now, through the exit of the MCO, we see still the impact because of the drop in tourism. It gladly took on the bank loan moratorium about to end in end of September. It is also tried to, like what Popo said, cut out a lot of the frills, or tried to manage a lot of its overheads. It's had to downsize and laid off some of its employees. With the gradual lifting of the MCO, fingers crossed there's not going to be a second wave. We've started to see a brief pickup in domestic tourism. But even the most optimistic of forecasts shows that eventual recovery is maybe 2022 onwards to try to achieve the same type of levels in terms of revenue. What's the nature of its debt? there are some secured debts because owing to several banks have charged over the lands of all 3 hotels. And there are also other unsecured debts in the picture because they owe other sorts of other trade creditors, suppliers. So there are now different groupings of debts that Highland Hotel owes. And unfortunately, things have advanced quite a bit throughout since from MCO in March until now. Legal suits have already started. So there are already pending legal actions. So there's now all pending in the courts. Legal actions have been taken. So that is where this case study on Highland Hotel is in terms of the facts. Maybe I will throw it first to Popo, I guess, to kick things off. What would be maybe either how would you walk through immediate steps that Highland Hotel may have to first take? Maybe my suggestion, quickly, please go and engage Popo as financial advisor. Bring her in. That would be my first suggestion. Take it from there, Popo.
I think number one, the company need to look at their own cash flow. What is it that they can conserve and what is it that they can manage, right? As you've correctly shared in terms of the cost cutting measures, they have done that, maybe put some of the employees on unpaid leave or some pay cuts, but they still have a job, they have benefits and whatnot until the hotel occupancy hits a higher rate, right? So talking to suppliers, I think suppliers they can give some form of breathing space, but only to the extent where they themselves are able to survive. If they can't survive, then they need to do what they need to do, like what you have stated there, in the sense that the legal suits are coming. So that one, I'll let Kumar deal with that. So it's very important now they manage the cash flow. So let's say they talk to the suppliers and say that, okay, I need extra credit period, right? The stakeholder confidence is very important in the sense that if they say that I need extra credit period, let's say from my usual 60, I need 90, they have to make sure that within that 90 they pay, because these suppliers gave that so-called, I would call it informal breathing space, with the understanding they will get paid within 90 days because they also have their own commitments towards their own suppliers, right? So that part is very important, right? Then, of course, talking to the lenders to basically have some form of again, breathing space lah, when the loan moratorium ends, having that conversation held and having a set of cash flow where the numbers truly reflect the company's position helps as well. And if the company were to consider any of those legal mechanism in terms of requiring a legal force field, right, then they also need to look at their financials in terms of whether their list of creditors is even correct, because most of the times when companies are under financial distress, the last one of the things that I won't say it's the last, that get deprioritized would be the preparation of the monthly set of accounts. That is important for decision making, and also the lenders also need to know how the company is performing, right? If the company is loss making and all that, how are they gonna recoup in terms of how they're going to operate? And the other one would be the directors are at risk for insolvent trading. Basically you are committing the company into a contract that the company has no way of completing it. So there is also a personal risk to directors as well. And then if you're a director, you also need to look at, in terms of your statutory payments to EPF and whatnot, that EPF can come after you in your individual capacity. So perhaps I will leave it to Kumar to perhaps share what can be done in terms of those pending legal action. Yeah.
Thank you, Popo. So looking at the facts that have been presented by Lishi, action has already been taken against the Highland Hotels, as some of the suppliers and other unsecured creditors have taken action. Of course, taking action means they can proceed and obtain judgment The issue is whether they can then wind up Highland Hotel. Well, for the time being, they can't because of the order made by the minister that during the 6 months period, the statutory notice, will not, the time period for the statutory notice doesn't kick in. But having said that, I think it came out in the news recently where creditors that obtained judgment against, I think it was a hotel or a business, they actually went and filed distress proceedings, okay, and tried to execute judgment in that way. So having said that, Highland Hotel cannot then risk having distress proceedings taken against as hotel operator. If they take a distress proceeding, you actually have to probably shut down the hotel. So having said that, to obtain the breathing space, of course, you need to go and try and see whether you can then apply for one of the rescue mechanism procedures that are available under our Companies Act. But looking at the facts of the matter, I noticed here that the Highland Hotels has got secured lenders, and they have in fact created a charge over their properties in favor of the secured lenders. That being the case, Highland Towers cannot use the avenue of creditors' voluntary arrangement because they have created a charge, and that will not be available. So the only other two rescue mechanisms that are available for Highland Towers is either to go in and apply for a scheme of arrangement or to appoint a judicial manager. With regard to a scheme, of course, as I mentioned earlier, you then have to then file an application for a restriction order, RO, and if you meet the criteria, then with the RO, a restraining order, creditors then cannot then take action against Highland Hotel. The other thing is, of course, you can also apply for a judicial manager to be appointed, and as we highlighted earlier, that once such proceedings, the originating summons is filed in court, you already get an automatic moratorium pending you getting the JMO or the Judicial Management Order. So these are the two avenues that are available for Highland Tower to at least obtain that breathing space that they require. Thereafter, of course, as Popo mentioned, you got to put your proposal and see whether the proposal is acceptable to the creditors.
Kumar, then you just mentioned about the one possible route of the JM application, but let's talk about Highland Hotel. You get a bit of breathing space by filing the JM application. One is that what could the if say you fail to adopt the tips from this seminar, you did not engage the banks, the banks are unhappy. What is it that the banks, what could the banks try to do to counter Highland Hotel's filing of the JM application? And two, maybe you can share also about the other unsecured creditors. Have there been any legal developments on what the unsecured creditors can also do to your JM application?
Yes. Of course, being a secured lender, who's got the benefit of a charge, more particularly a venture, can oppose a JM order. That is available under our Companies Act. There was always an issue as to whether unsecured creditors can oppose a JM order. Well, I mean, some earlier decisions have stated very clearly that unsecured creditors cannot. But subsequently, there has been a case where a JM order had been set aside because it was demonstrated that more than 25% of the creditors in value were objecting to the proposal that was being made, and therefore that proposal would never have got approved, and so on that grounds alone, the JM order was then set aside. So in that sense, even an unsecured creditor, if they have sufficient number and in value, they will be able to then indirectly oppose a JM order. Yeah.
So then, returning to Popo, I mean, I know I've not populated enough of the numbers here for Highland Hotel, but what could be one possible plan, or how can we sell this proposal to save Highland Hotel to our banks and to Highland Hotel's other creditors?
Put it this way, for the secured creditors, like Kumar said, it is so-called coded in our law. They have the right to oppose the JM application. I guess it solidifies their position as a secured creditor. If not, why take a security? So a softer approach, it would be, like I said from the very start, talk to the lenders. Talk to the lenders. You know, if they think that the undergoing a JM process will give the company a better chance of surviving in the medium and longer term, and if they think that they will be no worse off than initiating their own recovery over the security. In this case, it's a hotel. So I will touch about selling hotels in a short while, right? Then perhaps you can get their support to agree to a JM application. So if that conversation with the creditors, in case the lenders started early, right, the lenders can see what the company has done, what the company has tried and didn't go through, and why is it now they need this so-called legal force field, right?
Okay.
I'm not saying that lenders will agree. Like I said from the start, they have security, right? So what's the point of having security if you're telling them that you got to give chance? You know, they have that legal right. But sometimes at times like this, like Kumar shared, you know, when you have a financial crisis, you know, when everything drops, right, sometimes people just need to come together and agree on what approach the company is going to take to. So in this case, you're talking about hotel, right? So if they want to go and foreclose on a hotel, right, if it goes in the market that says that this hotel is up for auction and all that, okay, what's going to happen next? Occupancy is going to drop. Then the hotel got no cash flow. You know, people are suing them left, right, center. They have to close down. So if the hotel closed down, the value of the hotel will logically drop. For a simple fact, you know, hotels, you know, every time we go in a hotel, they have this nice furnishings and whatnot, right? It needs to be maintained. If you turn off the aircon, it will then grow moldy, as we have seen, you know. Remember when we had the MCO, when they first opened, then you have that photo that went viral about all the leather bags, you know, having all the mold and all the shoes, and everybody's like, you know, I'm not going to go shopping, you know. So same thing for a hotel, you know, it's like preservation of the value of the hotel. So we can see during the MCO as well, some of the hotels have decided to close down. Some say for renovation and whatnot, whatever reason that is. But when it is an orderly closure, the hotel owner themselves will make sure that the assets are being preserved. Okay, so in a sense, there'll be someone maintaining it to make sure that things don't go moldy and your TVs and your paintings don't go missing, per se, from the rooms. Yeah, so this is something they need to look at. Yeah.
Okay. And how do we plan out this recovery plan for something like Highland Hotel? Is it going to, does it necessarily need some sort of, like we said, right, savior white knight to come in? Could we sell to our creditors the plan that, look, kind of give us 1-2 more years for the entire Malaysian tourism sector to rise up? What could be some strategies or some narratives that I guess either Popo or Kumar you've seen before in similar thought situation that we can have a kind of a plan or a narrative that we can sell? Hopefully it becomes a success story for Highland Hotel.
Well, the easiest sell is always a white knight coming in to inject fund, to make the business better. You know, maybe the hotel complement with something else. You know, people can see an opportunity in that business. Okay. In the unfortunate event you don't have a white knight, it's a tougher sell. I won't say it's impossible. So whether the company's cash flow is able to sustain itself in the immediate term, and also able to offer some repayment of the old debts per se. So the only answer I have is actually it depends. You know, it also depends whether your creditors are patient enough with you, or they will just say, just call it a day, you know, pull the plug, and que sera, sera, whatever will be, will be. Yeah.
Yeah, Lishi, like I said earlier, it also depends. I mean, if a hotel had faced a similar problem, let's say a financially distressed scenario or situation during the good time, okay, because of its management or whatever, then I think of course the secured creditors or even the other creditors will take action, and they will probably pull the plug, because there will be a buyer out there will be ever willing to then take over a nice hotel or whatever at whatever price. But in the current situation, the availability of white knights is limited. Yeah. Here, I think the entire hotel industry, travel industry is down. Yeah. Of course, there may be pockets of entrepreneurs out there with deep pockets who may be able to then invest. But in this background, I don't think the secured creditors would be trigger happy to try and do an immediate sale, because there will be actually a lack of buyers. So given the situation that there will be, of course, a recovery of tourism and the industry, both domestic and international tourists, hopefully after they have actually got a vaccine and people start traveling more comfortably, there will be a pickup. And it's, I think, then better to allow the company to trade out of its financially distressed position. Yeah. So that's my view. Yeah.
Okay. Thanks, Kumar, Popo. I thought that with there are quite a fair bit of questions coming in, so I thought as well it will be useful then to try to move on to some of the questions, and of course we can jump back in to see any of the other points that we've covered. Just make sure that we are okay here. So I wanted to move on to the question section of where we're at now. I don't know whether all of the audience members have the benefit of the questions, but I'll just read it out slowly as well for the benefit of our speakers and our panel. I think, okay, I've got this. One of the initial questions was posed. I think it was indirectly covered already by the panel. When we're talking about a company in financial distress, and before opting to go for a scheme of arrangement, well, considering whether to go for a scheme of arrangement or judicial management, does the company need to pre-inform or dialogue with the creditors to gauge their support, or should the company just proceed to file straight away for a scheme arrangement or judicial management, presumably to buy breathing space? So either for Popo or Kumar to answer this question. Dialogue or file straight away?
I would think dialogue, both for scheme, as I think if you want to go for a restraining order, you need to actually now, as opposed to previously getting an ex parte order, you've got to serve it in existing creditors who have taken action. So since they have already taken action, I think you must, present them, get involved and have a dialogue with them. Even with regard to a JM, because of that limited period of time, for you to come up with a proposal and so on and so forth, you actually must have some sort of dialogue with at least your secured creditor, okay, before you go and file this application. Because if you don't, he will just oppose it, and that the whole process is not even going to start. Yeah. So in my view, dialogue.
Yeah, I mean, if you look at it from an approach perspective, dialogue would be preferred. Like I said from the start, having those conversations help if you have started like some time back. But of course, if you look at it strictly under the law, okay, the lawyers on this panel, and Lishi, you can correct me if I'm wrong. I think for scheme of arrangement, it is very clear that you need that dialogue. For JM, unless you have that secured character that you need to manage, there's no requirement. But then you can go and file and get that legal force field, but then they will challenge you at the JMO application hearing, and then you will still be back to square one. So why embark on a plan that you think will not be able to allow you to achieve your objective, right? So in undertaking this, always have a plan, in a sense that if I fail in this, what is my backup plan? The contingency planning in any of these approaches is important. So that is why always having that constant conversation with your key stakeholders is important. Yeah.
Another question, and I think it also touched on what Kumar had touched on earlier. We also are starting to see, of course, public listed companies in distress, despite any relaxation of the labeling of PN17. So maybe more for Kumar, but if Popo wants to weigh in also, I mean, any views on the legal position? Is JM allowed for PLCs? Can PLCs apply for JM? And I think Kumar, you can also share I think there's a live pending application as well, right, by a PLC?
Yes. Yeah. I think it was debatable as to whether PLCs are eligible to apply for a JM order, because as I earlier mentioned, if there's any company that a class of company that is subject to the subject to the CMSA, so you're listed, you're supposed to then go to the Securities Commission or whatever, and they then say that you are then come under or subject to that act, and because of that, you're not entitled to then apply for a JM. Although, of course, if you go back to the regulators, I think that was never the intention of the regulators. I think it was there to govern licensed institutions like banks and insurance companies and various other people that came under that provision of the act. But having said that, there is in fact a case, I think, that's pending on whether this issue is going to be determined. And that was also moved by, I think, some of the professional bodies to sort of recommend to the government to clarify this through legislation. So that's with regard to whether a public listed company may apply for can apply for a JM. So having said that, and if they have provided security or created a charge, then they are unable to go under a CVA, and CVA has got a similar kind of restrictions. So therefore, a public listed company is only avenue available would be a scheme of arrangement. Yeah.
Then when we are another question, both from I guess practical and a legal perspective, what would you share in terms of the possible pros and cons between judicial management and a scheme of, when you're looking at judicial management and scheme of arrangement? So what could you say are the pros and cons when a distressed company is trying to consider either of those two options? To either Popo or Kumar or both.
Okay, ladies first. I'll go first.
Okay.
Okay, I think the pro in a JM will be a con in a scheme of arrangement, right? So the immediate pro for JM would be your immediate legal force field, per se, upon filing of an application for a JM order, right? Versus a scheme of arrangement, if you want to get a restraining order, there are this string of conditions that you need to meet. And one of it would be that you have presented the plan, and the one that is difficult for some companies to get is independent director who has received the blessings of majority creditors to serve on the board during when the company undergo the process. So the con, like I say, so the con for JM will be a pro in the SOA lah, right? So the con for the JM would be, if it is an application by the company, the management of the company now lies on the JM. Okay, so in a way, the directors lose control. But then if it's a company-led process, then the directors would, I mean, so-called logically speaking, because this is the JM of their choice, they would work together with the JM to achieve the outcome of why the company have to go under the JM. But so on that note, if you look at the flip side, on the SOA perspective, the pro on the SOA is that the management and directors remain in charge running the company, right? So on a creditor's perspective, sometimes they may not want that, in a sense that, hey, you are the one that run the company to the ground, and then now you're saying you want to try and save it. Can it even be done? Then of course they say, hey, I got this independent consultant, this independent financial advisor that can advise us. So again, the choice of your advisor is also important. Whether is it someone acceptable by your so-called key stakeholders, basically your majority lenders, in order for you, or creditors, for you to get that 75% vote. So back to JM, you lose control. On the same note, if you look at the JM process where it is a creditor-led application, then this JM, I said the JM is always impartial. The JM is an officer of the court. So he or she will act impartial, regardless of who is the one that files that application. But technically, if it's the creditor that pushes that JM process, of course, the directors may not be that welcoming. But then it is something that I personally believe it can be managed, because after all, the JM, him or herself, is an independent party, and they are professionals, for simple fact that they are licensed to run this kind of engagements and take such appointments. Yeah. Kumar, you want to add? Yeah.
No, I think you have set out what the pros and cons are, and I think, but one fact I think that you need to take into consideration is what is the situation of the company at that particular moment in time. If they desperately need the breathing space, then maybe it's easier to go for a JM, because once you file the papers inside and get the JM judicial manager there, pending the hearing, you immediately get a moratorium. Whilst that of in the scheme of arrangement, you actually have to go to court and get this RO, and as Popo mentioned, there are so many criteria, and one of the things is to try and get a director that is appointed onto the board, who is then has the support of at least the creditors. But the disadvantage of the JM order is it's not merely, you see, in a scheme of arrangement, if you get through and you have set up a reasonably credible plan to the creditors, and the creditors abide on it, then it is easy for a scheme to then be approved. So long as the creditors approve, the court merely endorses the approved plan of the creditors. Of course, they will scrutinize it to see whether any particular class of creditors have been put in a disadvantaged position. But generally, they will endorse what the creditors have approved. But in a JM, you have the proposal, but you have also the criteria. There's a basic thing that you've got to cross the hurdle, which is whether your recovery under the JM is better than that you would do if the company is put in a winding up situation. So there's actually a slightly higher threshold, not merely because you need to go and get the approval of the creditors. So these are the two things that I think you have to look out for. Yeah.
Okay. There's one, because we're also running out of time, but there have been at least 2 questions or 2-3 questions on this area. kind of like the elephant in the room, or it's been a long promised elephant in the room. Are we going to have either a COVID-19 law specifically? I just went to check the parliamentary website, still no COVID bill or law. But if I were to give both of you wish lists as the practitioners out there to help with restructuring and rescue of companies, whether it is a COVID specific law or whether we were to come up with other amendments or other laws, what would be your wish list to allow for easier restructuring, rescue, or saving of companies in financial distress?
Okay, ladies first.
Yes.
I'll just touch on the financial part. Maybe Kumar can cover the legal part.
Legal part,
earlier in this webinar, Lishi, you did mention about how do we ensure that those trade lines continue to be utilized and whatnot. So if, in my experience in helping distressed company, right, what would be really nice to have is the ability for a third party to come in and provide rescue financing, as what we have seen across the shores, southern end, Singapore has done. This is something that whether it can go into COVID bill or perhaps a longer wish list will be eventually be built into our company side, because during the period of distress, right, the company needs some form of financing, right? So whoever that's willing to come in, there has to be an upside for them as well. Then on that same note, yes, we can look at certain relaxation of the restrictions currently in the Companies Act that disallows certain companies to enjoy some of these rescue mechanism, right? There has to be a fine balance between what the company can do and also a very healthy creditor protection. The creditors need to be protected. Like for simple fact now, you say you want to get restraining order, then you have that independent director part, which is very, very challenging. Then, so if I can take one side of the fence and say, can we dispense with it, right? But bear in mind, long time ago, that was put in to prevent an abuse. So there has to be some midway to cover that. Yeah. So perhaps Kumar can cover the legal part.
Yeah, any part. Yeah.
Yeah, I think Popo's covered some of the things, but of course, in each of the rescue mechanism procedures that are available, I think there need to be some tweaking of the law to make it, I think, more easier and more user-friendly, and so with regard to the scheme, I think the restrictions with regard to the restraining order, they should try and make it simplify it a bit more. There's a need, of course, to protect the creditors, but at the same time, is to not make it so difficult that some companies will not be able to obtain a restraining order, which is really required for them to have that breathing space. The other is to remove this issue that we have as to whether public listed companies can apply for JM. I think there needs to be some clarity with regard to that, because otherwise you are a whole load of public listed companies will not be able to enjoy this new rescue mechanism procedure that's been set out, and they're only restricted to the old law of going under the scheme of arrangement. Thirdly, I think with regard to the CBA, where there's this restriction where a company that's given a charge cannot then apply for a CBA. I mean, in reality, there'll be very few companies in Malaysia, a trading company or a manufacturing company, a small manufacturing company or whatever, that has not created a charge. And so you have then completely excluded a large number of companies from having this very simple CVA, creditors voluntary arrangement process available to them. And I think maybe the regulators or the people in charge should think about that, to allow wider use of all these provisions. Yeah, so I think these are some of my wish lists.
Thanks, Kumar. I think thank you very much to the audience as well for all of the questions. We just did not have enough time to answer all of the questions and answers. What we are trying to do also is to to condense and take away a lot of these questions and answers. Work via TWGRI and PEMUDAH, maybe try to compile these, especially if they are FAQs. In addition, thank you, of course, to my speakers, Popo, Kumar, and of course to the TWGRI team, Mr. Ganesh, of course, Jerry behind the scenes, he's behind the camera, for organizing this excellent platform. And hopefully this is only but the start, because I think like what Mr. Ganesh said at the very start, we hope that this now continues to create a platform to allow an exchange of ideas and views. So this, we are only hoping to be our part 1 of the series, with the strong support of Mr. Ganesh chairing TWGRI. Stay tuned for future seminar series on these issues, where we can then hopefully cover more of these content, address some of the questions. So with that, thank you, Popo. Thank you, Kumar.
Thank you.
Yes, and thank you everybody else, and thank you to the audience.
Thanks, Rishi. Thanks, everyone.
Thank you.
Take care. Stay safe.
Bye.
Bye.
Bye.